All right. I am told we are ready to begin, so I will start by saying good evening and welcome. My name is Jennifer Galloway, and I am the current president of the York County Bar Association, and we are honored to bring on this evening's program. On May 28, 1788, Alexander Hamilton published Federalist 78, titled The Judicial Department. In his famous Federalist paper essay, Hamilton offered perhaps the most powerful defense of judicial review in the American constitutional canon. On the one hand, Hamilton defined the judicial branch as the least dangerous branch of the new national government. On the other hand, he also emphasized the importance of an independent judiciary and the power of judicial review. With judicial independence, the Constitution put barriers in place, like life tenure and salary protections, to ensure that the federal courts were independent from the control of the elected branches. Today's program is brought to you by the York County Bar Association in partnership with York College of Pennsylvania, which we thank you tremendously for the use of this space. This event is a longstanding activity of our association, as is the Judicial Evaluation Poll, of which the results were released this afternoon. Please check those out. The format for our program this year is going to be different than in years prior because we do not have a contested judicial election. So, instead, we'd like to use this opportunity to educate and inform those of you in attendance. Both events, the Judicial Evaluation Poll and this forum, are undertaken as a public service and not for the purpose of endorsing any specific candidate or a political party. The information from this evening's program and the poll results are offered as a resource to the public. And now, please welcome Kevin Schreiber, President and CEO of the York County Economic Alliance, who will introduce our committee, panelists, and candidates.
Thank you so much, Jen. How's everyone doing this evening? Good. All right, good to see you. Thank you all for coming out tonight. Great evening to introduce our candidates and get to know a little bit more about them, and obviously learn a couple things along the way. Thank you to Jen, great job, and thank you for all of your volunteership to the York County Bar Association. Thanks everyone for joining us. It is an important judicial forum tonight where we will have an opportunity to learn about the judicial independence and why it matters, and obviously meet our candidates as well for the York County Court of Common Pleas. As Jen noted, this is not an endorsement. Vicki made sure that we stress this is not an endorsement. You got that, media? Not an endorsement. It's not an endorsement of candidates. We're simply getting to know them. However, it is an endorsement of both Jen and my remarks. So you can congratulate us later. And we have both negotiated, quite literally, a get-out-of-jail-free card for this appearance tonight. So it's not an endorsement. Okay. Our gratitude, obviously, to the York County Bar Association and its leadership for organizing this opportunity. So please help me thank the members of the committee for organizing tonight. So as I call out your name, please stand to be recognized. Remain standing so we may cheer for the lot of you at the conclusion. Obviously, Dr. Nicholas Anspach, who you'll hear from a little bit later, Dr. Dominic Della Carpini, Scott Fisher, and we've just heard from President Jen Galloway. Past Bar Association presidents, all of whom are Esquires, so I'll forego stating the suffix after each. Suzanne Greist, Craig Milston, and Suzanne Smith. Thank you all very much. And later this evening, you'll obviously be hearing from our president judge, Maria Musty Cook, and our retired judge, John Yoler. Thank you very much for joining us this evening. Now we have a couple judges in the audience. Will all of our elected officials please rise so we can thank you as well for coming out? In addition to judges, I know we have County Commissioner Doug Hoke. Anyone else? Thank you very much. And of course, to the fantabulous Bar Association team, Miss Victoria Connor, Cheryl Kaufman, and Tristalyn Bixler-Kint. Thank you. And as noted, we'd like to thank our host this evening. As Jen said, my alma mater. If it isn't yours, you're probably jealous. The York College of Pennsylvania. Thank you for allowing us the use of the space. Tonight, in just a few short moments, Dr. Nicholas Anspach, Director of the Gladfelter Institute for Public Policy at York College of Pennsylvania, will take us on a journey from Marbury versus Madison to our present day, discussing the importance of an independent judiciary in the context of America's systems of checks and balances. with special attention paid to the recent high-profile federal court cases. Immediately thereafter, Mr. Scott Fisher will moderate a conversation with Judges Maria Musty Cook and John Euler, both of whom have tremendous firsthand experience and will provide a local view on judicial independence. Thereafter, Scott will help us introduce our judicial candidates before winding down and wrapping up this evening. We'd also like to thank other partners who made tonight's forum possible. We've already mentioned York College Center for Community Engagement, the York Daily Record, White Rose Community Television, thanks Cliff, York County Economic Alliance, and of course the York County Bar Association. So, did you know that there are over 900 elected offices on the primary ballot in York County next week? I bet you didn't know it was 900. We do, because before every election, the York County Economic Alliance publishes a voter guide that is available right now at yceapa.org/vote, or you can find it on our social medias. We've been posting it recently. In there are all of the materials that anyone may need to understand how to go about voting, how to register, where their precinct is, how to vote by mail, how to vote in person, how to drop off a ballot, all of the voting processes, and all of the individuals, the candidates, and the offices that are on the ballot. You will also know, we'll also let you know if there's a particular ballot question. We try to give you all of the information that you would need to know before walking into the voting booth or before mailing in your ballot. So please, if you know anyone in this community who is unsure about voting next week or is unaware of who or what offices may be on the ballot, please feel free to share this information with them. And one final note, as if anyone forgot, next week is obviously the primary election. So if you've not yet voted and plan to do so in person or by dropping off a ballot at our county building next week, a simple plug for civility. Once a prerequisite for politics and the political process, today it's frequently overlooked. So please remember, most of those who you will encounter next Tuesday are volunteers or our county employees or our individual candidates. So please let civility lead the way. Now, with no further ado, Dr. Nicholas Ansbach is the director of the Gladfelter Institute for Public Policy at York College of Pennsylvania, having received his PhD in political science from Temple University. Dr. Ansbach's research has appeared in outlets such as Political Communication, Political Behavior, New Media and Society, Environmental Politics, Better Housekeeping, Research in Politics. One of those is not accurate. Additionally, he has received the American Political Science Association's Timothy Cook Award in Political Communication. And just having had a minute or two here to sit next to him and ask him a couple rapid-fire questions. His favorite cocktail is a Manhattan. Props. His favorite destination vacation would be Europe. Anywhere in Europe. Favorite guilty pleasure dessert, brownie with vanilla ice cream. Favorite guilty pleasure food is a milkshake. Brings all the boys to the yard. Favorite book, Flowers for Algernon. And favorite political movie, Good Night and Good Luck. So ladies and gentlemen, please help me welcome to the podium Dr. Nicholas Ansbach.
You know, I've seen Kevin speak a few times, and I've always thought, man, it must be so awful to follow that guy. Here I am. So we've had a couple disclaimers so far, but just one last reminder that this is an educational event, and participation should not be construed as endorsement of the candidates. Thanks for joining us and braving the rain. My talk today is going to be on the importance of an independent judiciary. And I'm going to start with a quote from Montesquieu, who was a political philosopher in French right before the American Revolution. He's widely credited with coming up with the idea of separation of powers, having separate branches of government responsible for the legislative, executive, and judicial powers of government. And he had this to say about the judiciary. He said, "There is no liberty if the power of judging be not separated from the legislative and executive powers." The idea is saying that freedom itself is at risk if we do not have an independent judiciary. Now, when I was coming up with this talk, I thought, how do I want to structure this? And with everything going on in American politics today, I said, you know what? I'm going to answer the questions that have been asked of me lately by family members, by friends, by my students. So that will be the structure of the talk. First, we'll go over judicial independence, exactly how we define judicial independence and how we protect it in the American context. Then we will pivot to evaluating whether the American courts truly are independent. And then finally, we'll end with the pressing question of what happens if someone ignores a federal court order. In the American context, what mechanisms do the courts have to enforce its rulings? But we'll start with that first question of what is judicial independence. Now, different philosophers have different ideas of what constitutes judicial independence, but in the American context, mostly what we're talking about is the idea that the courts are at least not directly controlled by the other branches of government. Now, that's not to say that the other branches of government don't have any input on how the courts are formed or operated, so that's why I have directly controlled here, directly in parentheses. We'll see later on in the talk how the other branches do influence the court, but they don't have direct control over the cases heard or the rulings of those cases. Judicial independence also means that the courts are free to make decisions without repercussions from the other branches. If the court rules against the other branches of government, are they free to do so without punishment? Will the judges remain on the bench? Will they still make their salaries? Judicial independence says that they are protected from that blowback. And judicial independence also says that judges should be insulated from shifting political climates. We have elections in this country every 2 years. Congress could change hands. Presidential elections every 4 years. The White House could change parties. And the idea is that we want our judges to be separated from the petty partisan politics that we all see in Washington, D.C. And our Chief Justice, John Roberts, has gone to great pains to try to keep that idea of an independent court separate from the rest of the politics of D.C. intact. Whether he's been successful in doing so, we might all come to different conclusions about that. Why is judicial independence so important? Why did Montesquieu write about judicial independence? Jennifer mentioned Hamilton's Federalist 78. We'll revisit that in just a moment. But why did he dedicate an entire essay to judicial independence? Well, one, in a system of checks and balances, judicial independence is an essential check on the more powerful branches of government. I agree with Hamilton that the court system is the least dangerous aspect of government, but in some ways it's the most powerful because it can hold the other two in check. You probably heard in your history courses or in your political science courses that Congress has the power of the purse, and the president has the power of the sword, of the military. The executive branch has the power to accuse people of a crime. It is the courts that protect the citizens from those powers of the other branches of government. Also, the courts guarantee due process for citizens and non-citizens alike. I just mentioned the executive branch's power to accuse people of a crime. Imagine if we didn't have due process here in this country. Imagine if the courts were just a rubber stamp for the executive branch. The executive, the president, could accuse somebody of a crime. The courts could just rubber stamp that, and you would be thrown into prison without a trial or without any evidence or any testimony against you. An independent judiciary protects our rights against a tyrannical government. And then also, an independent judiciary creates legitimacy for the actions of government. Again, if the courts were just a rubber stamp for, say, the president, any of the president's actions could be called into question. But because we have judicial independence, if the other branches of government, or if any of the 50 states do something that might be controversial, the courts can tell us whether that action was constitutional. And if so, if that action is allowed as deemed by the courts, it creates legitimacy for that action. We as a society have agreed to go along with what the court says. We might not agree with the court's decisions, but we abide by them because of that legitimacy. So as promised, I said I'd bring up Federalist 78 as well. To switch very much to the American context now, just a little bit of background about the Federalist Papers in case you have forgotten from your high school or college days. The Federalist Papers were a series of essays written by some of the founding fathers to convince the American people that the Constitution was a good idea. People were very concerned about this idea of a constitution because it created a stronger central government than what Americans had had in the few years prior. And they were concerned about this idea of a strong central government. They were concerned that it might just be a monarchy by another name. So the Federalist Papers were a series of essays meant to convince the American people that the Constitution was a good idea, but was also meant to address some of the fears people had about this idea of a strong central government. And in Federalist number 78, Alexander Hamilton argues, hey, you might be scared of a strong executive. You might be scared of a strong Congress. But don't worry, because we are going to have an independent judiciary. And we have to have this independent judiciary. The judiciary, to quote Hamilton, would have everything to fear from its union with either of the other departments, the other branches. It is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches. So in Federalist number 78, Hamilton lays out the ways that the Constitution will protect American judicial independence. So let's look at some of those mechanisms in the Constitution to maintain judicial independence. And actually, Jennifer mentioned some of these in her introduction. But the first is the idea of lifetime appointments for judges. The Constitution stipulates as long as judges remain on good behavior, they will serve for life. We do not have elections for federal judges in this country. The idea being, of course, that we want judges to rule according to what is right, according to what the law says, rather than what is popular. Also, lifetime appointments help insulate the federal justices, the federal judges and justices, from political consequences if they do indeed rule against the other branches. A less eye-popping but still important aspect in the Constitution protecting judicial independence is that of constitutional salary protections. And credit to the forefathers for sticking this in the Constitution. I wouldn't have this foresight. But imagine, someone has a lifetime appointment as a federal judge. They rule against me and my legislative branch, and I can't remove them because they have a lifetime appointment, but I could get back at them by passing a law that sets their salary to $1 per year. They would be forced to retire in order to maintain their livelihood. The forefathers foresaw that possibility, so it is in the Constitution that the federal judiciary, their salaries are protected. Whoops, I'm sorry. And then finally, the most powerful tool in the federal judiciary's toolkit is judicial review. And judicial review is so important and so powerful that I want to spend just a little bit more time talking about what it is. Simply put, judicial review is the power of the federal courts to declare an action by government as unconstitutional. You might be familiar with the Supremacy Clause in the Constitution. That's the idea that every law and every action government takes in this country must abide by the Constitution. Judicial review is the power of the courts to determine whether that's so. And in this country, if a law or an action is deemed unconstitutional, it's voided. So that means any executive action by the president, say an executive order, any law passed by Congress, or even actions by our state governments are subject to judicial review. Now, a little bit about judicial review. It's not in the Constitution. Even though Hamilton wrote about judicial review in Federalist Number 78, the founders did not include it in the Constitution. The Supreme Court actually gave it to itself in the case Marbury versus Madison. And for the most part, it has stuck ever since. Also, a neat aspect of judicial review, the United States has a very strong system of judicial review. If the Supreme Court declares something as unconstitutional in this country, that action does not stand. That is not the case in other countries. In other countries, their courts might review a law or might review an action, and they might rule, hey, this is unconstitutional. This goes against common law. But it's just an advisement. They don't have any enforcement power. It would be up to the executive or up to the legislature to go back and change the law to be in accordance with the Constitution. In the United States, we have an especially strong system of judicial review. So that is what is meant by judicial independence. Moving on to the next question I've heard a lot is, well, are our courts truly independent? And I'm here to tell you at our panel on judicial independence that they're not entirely independent, because we have a system of checks and balances in this country. Yes, the court can check the executive branch, and yes, the court can check the legislature, but those branches also have checks on our court system. The president, his check on the courts is the power to appoint federal judges. This is true for all levels of the federal judiciary. We'll see what those levels look like in just a moment. But remember, because federal judges serve lifetime appointments, this is the president's chance to really put their stamp on the federal judiciary. Because presidents are going to serve 4 years or 8 years at most, but because these judges serve lifetime appointments, they will serve 20, 30, 40 or more years on the bench. And the president is going to pick people with whom they agree. So, for example, President Donald Trump right now, a conservative fellow, he is going to select similar, like-minded, conservative judges, not just for the Supreme Court, but for the entire federal judiciary. Congress also has checks on the judiciary, and in many ways, Congress has more important checks on the judiciary, some of which we're probably all familiar with. For example, we probably all know that the Senate confirms presidential appointments to the bench, again, for all levels of the federal judiciary. We hear a lot about impeachment in recent years, but a reminder that Congress can also impeach and remove federal judges from the bench. That would require a majority vote in the House to impeach a judge and a 2/3 vote in the Senate trial to convict them and remove them from office. Also, the courts are responsible for creating the lower courts. The Constitution creates the Supreme Court. That is in the Constitution. We have to have a Supreme Court. The Constitution creates the office of the Chief Justice. We have to have a Chief Justice. But everything else has been at the discretion of Congress. Here is a simplification of our federal court system. You know, we have extra things like military courts and immigration courts, but for the purposes of our talk, this is the structure of the federal court system. We're all familiar with the U.S. Supreme Court. At the top, we have 9 justices there. They are the top court in the land. But most federal cases start at the bottom here, in the U.S. District Court. Every state has at least one district court. Pennsylvania being a larger state, both in size and in population, we have 3. Right now, we are in the middle district of Pennsylvania. Most federal cases begin and end at the district court level. Congress is responsible for creating those district courts. If somebody doesn't like the outcome at the district court level, if they have good reason, they can appeal to the middle level of the federal court system. That's the U.S. Courts of Appeal. also known as the appellate courts, also known as the circuit courts. We have 13 of those. The districts, of course, are going to be much larger. And then somebody could appeal directly to the Supreme Court. But at the district and appellate court levels, again, those courts exist because Congress passed laws creating those courts. And hypothetically speaking, the Congress could also pass laws dismantling those courts as well. The Constitution only stipulates we need to have a Supreme Court and we have to have a Chief Justice. That's the checks and balances. That's the broad view of how the other branches maybe threaten judicial independence. But there's also been events in the news recently where there have been attempts to control the independence or control the courts. There's a law currently under consideration in Congress. It's called the No Rogue Rulings Act. Now, I'm skeptical this bill will become law, but it shows an attempt of Congress to claw back some of the power from the courts. This was introduced by some Republican lawmakers because there have been some recent rulings from the federal courts that those lawmakers don't agree with. Many of those rulings have occurred at that bottom level, the district court level. Here's a map of all of the district courts in the United States. And these Republican lawmakers have a problem with a district judge in one of these smaller districts issuing a ruling that applies to the entire nation. And on one hand, this makes sense. I mean, this seems reasonable. For example, why should a district judge here in southern Louisiana be allowed to make a ruling that applies to the entire country when their jurisdiction is just southern Louisiana? This law would prevent that. This law would prevent district court judges from making a ruling that goes into effect for the entire nation. And as I said, at first glance, this seems entirely reasonable. Until you remember, we are talking about federal law. We are talking about federal cases. Federal law applies to the whole country. Federal law doesn't care whether you live in Louisiana or Vermont or Hawaii or York, Pennsylvania. Federal law applies to the entire country. You can't have one version of a federal law in Louisiana and a different version of the same federal law for Florida and a different version of the same federal law for California. Federal law doesn't work that way. It's a law for the entire country. So even if Congress were to pass the No Rogue Rulings Act, I am skeptical it would hold up under judicial review in the courts. I think that law would be deemed unconstitutional. Another way that we see the Congress, maybe public opinion, try to influence the independence of the court is with court packing plans. You might have learned about court packing plans in a history class when learning about the New Deal and Franklin Roosevelt. Franklin Roosevelt had a series of initiatives that he wanted passed in order to combat the Great Depression. Some of those initiatives were deemed unconstitutional by the Supreme Court. They used their power of judicial review to strike down some of those initiatives. Franklin Roosevelt didn't appreciate that. He thought these initiatives were necessary in order to combat the Great Depression. So what he tried to do was appoint extra justices to the Supreme Court. At the time, there were 9 justices on the Supreme Court, just like there is today. He wanted to appoint more like-minded judges who would then rubber stamp his agenda. In a way, getting rid of that judicial independence we're talking about today. Now, ultimately, Franklin Roosevelt's court packing plan was unsuccessful. Congress did not go along with it. But we see some rumblings about court packing discussions taking place today. And that's because of the current makeup of the court. If it was Republicans who were trying to pass the No Rogue Rulings Act, well, it's the liberals in the United States that are talking about packing the court because of the court's current ideological makeup. Despite our Chief Justice John Roberts attempts to keep the court above petty partisan politics, most of us see the court through this lens, through an ideological lens. Those 3 justices circled in red are the court's liberal members. Those 6 circled in, I'm sorry, the ones circled in blue. I have my PhD in this stuff, I promise. The ones circled in blue are the court's liberal members. The ones circled in red are the court's conservative members. And there was some controversy about how some of these Republican-appointed justices got to the Supreme Court bench. We're not going to get into those controversies now, but it left some Democrats feeling cheated out of some of the seats on the Supreme Court. And you hear some discussions, even among some of the more liberal members of Congress, that perhaps a Democratic president should appoint some extra justices to the Supreme Court to kind of even the scales. Is that constitutional? Yeah, it would be. Remember, the Constitution only says we need a Supreme Court and we need a Chief Justice. Everything else is at the discretion of Congress. But just like the No Rogue Rulings Act, I am very skeptical that a court packing plan would actually take place. But it goes to show yet another attempt, if you will, to threaten judicial independence. We also see the fight for public opinion when it comes to some of these federal court decisions and federal justices. Our current commander-in-chief, our current chief executive, loves making his social media posts. I can't call him tweets anymore because he's not on Twitter. They're truths now, I guess. But here's a recent one that he made at the end of last month where he's going after a law firm that took some cases against him. We're not so much interested in his attack on the law firm. I have this tweet up here to illustrate his attack on a member of the federal judiciary. He says he found out that the judge assigned to this case is Beryl Howell, an Obama appointee, and a highly biased and unfair disaster. She ruled against me in the past in a shocking display of sick judicial temperament. He goes on to say her ruling was so pathologically bad that it became the talk of the town. I could have had a 100% perfect case, and she would angrily rule against me. It's called Trump derangement syndrome, and she's got a bad case of it. To put it nicely, Beryl Howell is an unmitigated train wreck. Chief Justice John Roberts issued a rare rebuke, if you will, against this sort of incendiary rhetoric against the federal judiciary. Again, trying to keep the court out of petty partisan politics. But again, we could have discussions whether he's successful in keeping the Supreme Court out of those political debates. One other way that the other branches might threaten judicial independence is by simply ignoring unfavorable rulings. And that segues into a recent case. You might be familiar with this case. The man on the screen, his name is Kilmar Abrego Garcia. And if you're not familiar with the case, just permit me a moment to give you a timeline of what happened to Mr. Garcia. He is not from the United States. He is from El Salvador, and he came to the United States, and he came here citing political or persecution back home. He said he was unsafe. He sought asylum. So there's a court order saying, okay, if it ever happens where Mr. Garcia has to be deported from the United States, deportation is allowed, but he cannot be deported to El Salvador because it would be unsafe for him to return to his home country. He has been in this country under asylum for quite a while. In March 12th of this year, he was detained. And I want to make the point that no criminal charges were filed in this most recent case that I'm talking about. 3 days later, he was indeed deported to El Salvador, despite that court order saying he can't be deported there. Authorities, the Trump administration, in court documents admitted Mr. Garcia was deported due to an administrative error. His family and civil rights or civil liberties organizations took his case to federal court. It went all the way to the U.S. Supreme Court under a fast-tracked docket, and on April 10th, the U.S. Supreme Court ordered the Trump administration to facilitate his return. But as of today, he is still in El Salvador. Now, whether or not the Trump administration is outright ignoring an order from the Supreme Court, or whether they're doing the best, but it's complicated dealing with another country in El Salvador, getting them to return a man who is a Salvadoran citizen back to the United States, where you fall in that debate probably depends on your politics. But it does lead us to the final question of the talk, and that is, what happens if somebody ignores a federal court order? I've heard people say we're in unprecedented times with the Garcia case, and I have to put on my professor hat saying, well, actually, that's not true. Unfortunately, this is quite precedented. We have unfortunate examples of different branches of government ignoring federal court orders peppered throughout American history. Perhaps the most well-known is the court's unanimous decision in Brown versus Board of Education in the mid-1950s to use its power of judicial review to strike down state laws segregating public schools. As you're aware, Jim Crow South segregated white and black students into separate schools, but the Supreme Court ruled that the 14th Amendment prohibited such segregation, and they ordered the states to integrate the schools with all deliberate speed. That was their order. But the South instituted a policy that we call massive resistance to integrating the schools. And one of the most prominent figures of resisting the Brown versus Board of Education is this man here. His name is Orville Faubus. He was the governor of Arkansas during the time that the Brown decision was being implemented. And Orville Faubus said, while I am governor, no school will be forced to mix their races. That was the language he used. No school will be forced to mix the races. Orville Faubus actually called out the Arkansas National Guard and posted them at the entrance to this high school here. This is Central High School in Little Rock, Arkansas, the capital of Little Rock. 9 black students were set to enroll in Little Rock, Arkansas, in Central High School in Little Rock, Arkansas. Orville Faubus used soldiers to prevent children from going to school. Let me say that again. He used soldiers. Think about what we use soldiers for. We use soldiers for fighting wars, for shooting the bad guys. He used soldiers to prevent black kids from going to school. In a clear violation of the Supreme Court's order. The president at the time was Dwight Eisenhower. Dwight Eisenhower, a general during World War II. Dwight Eisenhower, who was in the beginnings of the Cold War against the Soviet Union. Dwight Eisenhower, who knew that this looked bad on the international stage. He nationalized the Arkansas National Guard, federalized them, meaning he took over command of the Arkansas troops, ordered them back to their barracks. No more soldiers blocking the entrance to Central High School. Orville Faubus decided to close Central High School in response. It's called the lost year. They just didn't go to school that year. All the white kids went to private schools. I suppose the black students went back to the schools that had been segregated previously. About a decade later, Congress, here's a picture of Lyndon Johnson, President Lyndon Johnson, addressing Congress, urging them to pass the Civil Rights Act of 1964, which they eventually did. Basically made racial discrimination illegal in this country. Why do I bring up this example? Because it shows that even though we have judicial independence in this country, oftentimes the courts rely on the other branches to enforce its rulings. It wasn't until the executive and the legislature got on board that we saw true integration in the South. And in fact, Alexander Hamilton addressed this all the way back in the 18th century. He said, the judiciary has no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm even for the efficacy of its judgments. Hamilton recognized the court has no enforcement in and of itself, that the president, the executive branch, and the legislature must get on board in order to make sure the court's orders are followed. In a way, it's almost like a house of cards. If people stop following the Supreme Court, the other branches decide to just ignore its rulings, then we're in unprecedented times if that becomes widespread, because the court has no mechanism for enforcement. And we have seen that a few times. You might have heard the quote from President Andrew Jackson. John Marshall, the Chief Justice of the Supreme Court at the time, John Marshall has made his decision, now let us see him enforce it. Historians don't think Andrew Jackson ever said that actual quote, but it was in regard to a Supreme Court case called Worcester versus Georgia. I'm not going to go into the details of Worcester versus Georgia, but it does concern a man named Sam Worcester, who was convicted under Georgia law and thrown into prison. He took his conviction to federal court and went to the Supreme Court, and using the power of judicial review, the Supreme Court said, hey, that Georgia law that Sam Worcester was convicted under, unconstitutional. Let Sam Worcester out of jail. What did Georgia do? Nothing. They kept him in prison. Sam Worcester turned to the president, Andrew Jackson, said, hey, Supreme Court said I should go free. And here I am still stuck in prison. Can you do something? And Andrew Jackson declined. The president did not enforce the Supreme Court's ruling. And Sam Worcester rotted in prison for another year until he begged for a pardon from the Georgia governor that eventually was released. But we might say, oh my God, imagine that. Imagine if you were convicted under a law that was overturned, you were put into prison, the Supreme Court said you should be let out, and the president said, I'm not going to enforce that. That seems unfathomable in the United States until you remember that's exactly what Mr. Garcia is going through right now. Put into prison in El Salvador, the Supreme Court said bring him home, and the administration, at least so far, hasn't done so. So, what happens? What happens next, right? What happens if this does become widespread, where Congress and the president decide we don't have to listen to the Supreme Court. We don't have to listen to the federal judiciary. What other tools are in the Supreme Court, the federal judiciary's toolbox to enforce its will? Well, one possible way to rectify things would be if Congress was on the court side. Because remember, Congress has the power of impeachment and removal from office. But it requires a majority in the House, a majority vote in the House to impeach a president, and to impeach a judge, a federal judge, and it requires a 2/3 vote in order to remove them from office, 2/3 in the Senate. A Republican-led Congress will not impeach or convict anybody in a Republican president's cabinet for something like this. It would have to be wildly egregious behavior in order for a Republican Party to impeach and remove one of its own in this current political climate. So I think impeachment and removal from office is off the table. Another mechanism the federal judiciary has in its toolbox is a contempt of court charge. Well, this is a criminal proceeding where if a federal judge says, hey, I gave you an order and you ignored it, they can open up a criminal case investigating whether or not criminal contempt of court took place. And in fact, we do see the beginnings of this process with some of the cases. There's a case where some Venezuelan immigrants were deported back to Venezuela, or actually to El Salvador, despite a federal court order telling the administration, don't deport these people, wait until their due process can play out in the courts. They were deported anyways. So the federal judge, his name is Judge James Boasberg, has started the process of criminal contempt. Now that process, I think, was held up in the appellate court, but this goes to show there is another tool in the court's toolbox. Admittedly, it's a rather weak tool. The maximum punishment for criminal contempt of court is a $1,000 fine and up to 6 months in prison. But no federal court is gonna throw the Secretary of State in prison, right? And again, unless it's something egregious. So these are fairly weak mechanisms. So judicial independence, it's important and it's necessary. But recognize that the courts still need to rely on the other branches of government in order to have its rulings enforced. Hamilton knew this in the 1780s, but I would say it's still a weakness of our courts, that there's no enforcement mechanism. And that's saying something because we do have one of the strongest court systems in the world with the American version of judicial review. So I think that would be a good opportunity to ask maybe some of our judges to weigh in. So I'm going to hand it over to Scott Fisher of the York Daily Record, and he can bring it back to the local level.
Thanks, Nick. That was a fascinating discussion of an issue that honestly couldn't be more important or timely. So a fun fact about Nick is that he completed one of my personal bucket list items when he appeared as a contestant on Jeopardy in 2018. And I think his talk made abundantly clear that judicial independence is in jeopardy in this country for many of the reasons that he talked about. So now it's on to our question and answer session. And for the record, no need to answer in the form of a question, unless you really want to, you can do that. So I'm going to read a little spiel about our two guests here. I'm honored to share the stage with two legal lions of York County, retired former President Judge John Euler and current President Judge Maria Musty Cook. I vividly remember my first meeting with Judge Euler. It was my first year in York, and I was he invited some editors in to basically sell us on the idea of building a new courthouse. And I vividly recall him complaining about what he called the bacon room, which is this room that I guess smelled like bacon in the old courthouse. And then he gave us a really interesting and compelling tour. And spoiler alert, the new courthouse was built with our support, our editorial support. Judge Euler has presided over some of the most consequential and important cases in York County history. And Judge Musty Cook is similarly a trailblazer in York County judicial history, having been chosen by colleagues as our first female president judge, not coincidentally on the 100th anniversary of the passage of the 19th Amendment giving women the right to vote. In her time on the bench, she has presided over many fascinating and important cases. And breaking news, as today, as I understand it, Judge Michael Flannelly has just been chosen to succeed Judge Musty Cook in January as president judge. I think, let's see, I will say that, so we're here to talk about why our judicial race is important. I think that's pretty obvious, but we're going to talk to some folks who have been in that position to understand what they do, why what they do is important. I will say that in terms of judicial races for journalists, we're kind of conflicted about them as political races because they're frustrating because our natural inclination is to learn and report as much as we can about candidates, who they are, what makes them tick, what they think about hot-button political issues like abortion or the death penalty, things like that. And of course, they're constrained by the Judicial Code of Conduct from talking about such political issues. So we'll get to that particular issue eventually, but let's begin with a fairly broad question. Could you explain to the audience what is the role of a state court judge?
I may start a little bit askew, but I'm known for that. While judicial independence may not have appeared in jeopardy, it's amazing to me and astounding to me that after 55 years of practice of law, when I'm experiencing at this time that the term judicial independence is a bad word. It certainly is not. And I'll set that topic aside for a later moment. But the first question asked, what is the role of the state court judge, and what are the categories of cases that state court judge will encounter? And I'll deal with it, as I'm known to do. A state court trial judge interprets and applies the state's laws. He or she will preside over non-jury or jury trials in order to resolve disputes and protect individual rights as called for under the state constitution and the laws of the Commonwealth. The state court, as in the federal court, it serves as a check on the executive branches, assuring the laws and/or actions comply with the state constitution. The categories of importance of state trial judges in doing their job are matters such as assuring a free and fair election under the state laws, access to education, protection of consumer rights as dictated by the state laws, the environmental protection laws dealing with quality of air and water. But more typically, and as equally important as the above, are issues regarding domestic issues, family law matters, custody, and all those domestic relation matters that arise from parenting a child and dealing with families in the Commonwealth of Pennsylvania. There are also estate matters, which are increasingly occurring, which deal with, obviously, estates, but it goes beyond that. Adoptions, guardianships, trust, and issues that typically deal with property issues, but inevitably necessitate one of the fundamental matters that a judge has to bring forth, and that's to deal with each case fairly and impartially. The headline cases, some of them, the criminal matters, those too can be dealt with by a judge without a jury. Not often, but it happens, or jury trials, as well as those cases that may be before the court as an appeal from a judgment made by a magisterial district judge, the review process that our local state trial judges, common pleas judges, undertake in their role as a sitting judge. Obviously, We are subject to review of our own decisions in our interpretation of the law. But it's important, too, that we recognize that in this Commonwealth, that the vast, vast majority of cases, civil, criminal, and the like, that are filed in the Commonwealth of Pennsylvania when weighing the federal court against the state court, I would suggest anecdotally that 95% of the cases emanate through the state courts, with a real minority through the federal courts. That's a Cliff Book summary of the role of a state judge, the functions of a state judge. I may have stealed some thunder from Paul and Chris, but so be it. That's the way things happen in these matters.
We're going to have to keep our answers a little bit shorter if we want to get through this evening.
You forget it's me.
I'm going to skip question number 2. This one is mainly directed to Judge Musty-Cook. Is judicial independence at the state court level different than the federal courts?
Well, there are some obvious differences. First of all, we don't appoint judges at the state level. We elect them. Whether it's appellate or trial court judges, they're all elected. They're not appointed. So we don't have that one person making a decision with the confirmation of the Senate. We have the general population who is registered to vote to select our judges. And there's debate about whether that's better, whether it should be appointment or election, and I think either argument can address the political nature of both the appointment process and the election process. But I believe in York County, at least, for many years, we had judicial candidates who cross-filed and didn't particularly parlay to either party. There are exceptions to that rule, of course. But I think under our system, it has worked here in York County. Additionally, we don't get to serve for life. We have 10-year terms, and then we have to run for retention if we haven't reached the magical age. So again, that requires the vote to retain. Now, it's not a contested election, but it is a, yes, I'm pleased with how this judge has performed, or no, I don't think he or she has done such a great job. So there is the retention vote that gives the voters a voice in the outcome of elections. And there have been in recent years, I remember this happened in my year of being elected, there are campaigns to clean house and get rid of anybody who is already on the bench or in a publicly elected position. And I don't know that the general populace, if they really thought that process through, would think it's such a grand idea, because what happens if you vote no in a retention election is you have a vacancy for 2 years, unless you're lucky enough to get a governor appointment. So basically then what you're doing is leaving the work of a full bench to a partial bench to get done, which is going to slow down the process of ensuring that justice is served to everyone. So that is 2 ways in which we're different. Now, we still have those same checks and balances at the state level. We still have an executive branch with the governor. We still have the legislative branch, and we have the judiciary. And each of us have our own individual roles. But if we don't work together to some extent, then we can't really perform as well as we should, or as well as the electorate would have us perform. We need to understand that just because we talk about judicial independence, that does not mean that judges get to do whatever judges want to do. We take an oath of office to support and defend the Constitution of the United States and the Constitution of Pennsylvania and all of the laws enacted thereunder. So it is our job to make sure that the rule of law continues, that people are following the law, that if there's a question as to the interpretation of the law, that we can answer that to the best of our ability. And that's how we operate on a day-to-day basis. So those are some of the differences.
Great, thank you so much. Now on to the free speech question. How does the Code of Judicial Conduct affect a judge's free speech and ability to comment on matters in the public eye?
It answered directly is it does, and predominantly in the area of interplay between the Fourth Estate, John Q. Citizen, and others that may enter the foray. A judge is not permitted to comment upon a case that is before him or her in a fashion that is outside the realm of the court proceeding. It's important to remember that while a judge has an educational role for the public, it should not be contemporaneous with a case that's before him in the courtroom or her. The impact of that is simply that it could tip the scale if the information received is of such that prejudices the trial, that impacts the jurors or future jurors that might be awaiting another case of similar circumstance. So that's an important distinction. Another arena is that a judge should not enable himself or herself to become a respondent to challenges made to him or her regarding the manner in which he or she is trying their case or has tried cases, or an attempt to prejudice or bias the public against that judge, which alternatively has the effect of, well, does this judge conduct him or herself in a fair and impartial fashion? Free speech is limiting, and it's limited by the Code of Judicial Conduct in a manner in which it hopes to assure that there's a fair and impartial trial before that jurist.
Thank you. What factors must a judge consider if asked to recuse or disqualify himself or herself in a case assigned to him or her?
Well, we are governed by the Code of Judicial Conduct, and that is pretty specific on this area. A judge must disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, and they give us some specific areas. The most important of which, if the judge has personal knowledge or bias against a party or a lawyer involved in the case, or has knowledge about the facts that are in dispute. If you are related, obviously, you or your spouse are related to the party within a third degree of relationship, or if you have a de minimis interest in the case, or more than a de minimis interest in the case, or you're likely to be a witness, obviously, the judge should be disqualified. If there's an economic interest in the matter, that's another reason for disqualification. If a party or a party's lawyer or lawyer's firm made a direct or indirect contribution to the judge's campaign that would cause a reasonable person to think that there is a question as to impartiality or fairness, there must be recusal. And there's been a lot of debate about, well, what is that, a magic amount that would set somebody to think that there would be a question of a lack of impartiality or fairness. And basically what has been given to us in the comments to that rule are, we are required annually to report certain financial interest. One of those is if anybody has gifted, other than a direct family member, like a spouse or a child, a gift of more than $250. So if somebody contributed more than $250 to your campaign, then you need to, first of all, disclose that. And if there's an objection, then decide that maybe you should recuse or be disqualified. Obviously, if a judge has made a statement about the issue that's before him or her, which would lead someone to believe that they're going to rule in a particular manner, that would be a reason for disqualification. If the judge or a former partner or associate of the judge served as a lawyer in the same controversy at an earlier time, obviously another reason for disqualification. Now, as I indicated, for a number of those examples, the judge can make the disclosure to the parties and the lawyers in open court on the record, and then excuse himself or herself and let the parties discuss whether the parties believe that the judge can act fairly or impartially. But if it is one of those specific categories, then I would say if they say, no, we don't want you, it's time to disqualify yourself. If they say, oh, we just don't think you can be fair and impartial for whatever reason. You don't like cats and this is about cats, or you don't like dogs and this is about dogs. That is a personal decision of the judge to recuse oneself. And if they decide that they can fairly and impartially judge the case, they may move forward, even though one or the other parties has requested a recusal. So that's pretty much the reasons why you would disqualify.
Okay, thanks. So we have less than 5 minutes for this last question. Goes to John Euler. What action should a judge take if personal threats are made to a judge or his or her family from litigants in a case?
I'll follow along with Maria's recent comments on disqualification. That may be one of the reactions that judge should take, but this is a fact-specific type of issue that one has to look very closely at. Let's start at the beginning, that a judge should not seek to or take action that almost invites his disqualification. A judge shouldn't appear at a racially charged event on a podium in support of whatever's going on. That's an obvious. But on the flip side, you can have parties that are savvy, that take action against a judge contemporaneous with the time that judge is about to undertake that party's hearing, and hope by that conduct that this will create such an issue that it's an appealable issue, or the judge will recuse. But it's indeed almost a form of forum shopping, dependent upon some of the steps taken and the time and way that it's taken to discourage having that judge hear the case, not for any perceived global issue of fairness or unfairness or a lack of impartiality, but he or she just does not simply want to have that judge. I had that situation early on, and I had a letter written to my home, and it did contain what would be challenging language, and also identified some family members. Now, ordinarily, when you get into the family, that may be yet another elevation of the threat. But the bottom line is, it was not a chargeable threat. It was a threat specifically undertaken to get me off the case. I refused. You can have threats of impeachment, threats of removal from the bench, threats of all fashion of things when involved with a major case, and they have happened, and it has happened. But the judge has to weigh his or her ability to fairly and impartially try that case. The one time it did happen, there was multiple defendants, and the multiple defendants and the family members of the victim, or victims, didn't want me removed. So it was a no-brainer that disqualification did not occur, because these were third-party objectors. It's a matter of making the right decision based upon the facts' specific nature, and all of which, once again, to assure the fair and impartial treatment by the judge of the litigation before him or her.
Thank you. I want to thank both of you so much for taking the time to join us this evening. Bring up our judicial candidates. All right, well, thank you. So we have our two primary candidates who will be on the ballot on Tuesday, a week from today. And I hope everybody has either voted already or will on Tuesday. And so I'm going to really shorten my little intro spiel here and just jump right into the questions. We have Paul Minnick and Chris Farrow, who are both, I believe you are both cross-filed and will be on the ballot unless something very strange happens in the fall after the primary. So this is a good opportunity for our community to get to know these two candidates a little bit better, the two people who will be sitting on the bench. Not sure where they'll, what particular part of the bench that they will serve on, but we will have these folks on the bench with us. So I'm going to just jump right in, and we'll sort of just go back and forth, we'll start with one and then flip back. So Chris, why don't we start with you? Why do you wish to be a judge? Simple question.
So I'm a firm believer in the power of one, and in essence, it's just a simple concept that says that I believe that one person at the right time, at the right place, with the right skill set, can have an incredible impact on individuals and their community. And I know that concept worked very well because I've been the recipient and the benefactor of it my entire career, my entire life. Whether it's a family member who supports you, whether it's a teacher who encourages you, whether it's a judge that takes you under their wing, whether it's a lawyer who mentors you, all of these things move you along and make your life better. And so for the past 25 years, I've practiced law and I've had a view of the bench, and I've come to the conclusion and assessed that that is a fairly strong and large platform in which one person can make a significant impact on the individuals in our community and on society as a general. And so I certainly go into this with a huge level of humility, not sure that I'm up to that weighty challenge, but it's what drives me and is what driven this decision of making me want to do this.
Mr. Minnick.
Thank you. Well, first of all, thank you everyone for coming out tonight. It is delightful to see this level of public interest in these important civic issues. I will just warn you, the exciting part of the program is now over. This will be more tedious, but candidly, I did not ever contemplate being a judge of the Court of Common Pleas in any respect. The issue first got on my radar screen when retired President Judge Steve Linebaugh took me to lunch at Revival in December of 2023 and presented this issue to me. I was somewhat dismissive of it. It's really only a testament to my respect for Judge Linebaugh that I even contemplated it. But I was extremely flattered, and I thought if Steve Linebaugh is asking me to look at this, I really ought to look at this hard. So I did due diligence. I talked with my colleagues. I talked with friends. I talked with retired judges. I talked with current sitting judges about their experiences on the bench, and it was truly inspirational. Every judge that I communicated with told me how meaningful their work was in York County, how much they enjoyed it. The terminology "best job I ever had" was repeated to me. I've not heard any lawyer in private practice use that terminology. So it was really kind of galvanizing and ultimately very inspiring. It's a little bit nerve-wracking to put yourself in the public domain and do something like this, but ultimately concluded it would be a beautiful way to serve the community. I was born here, spent my entire life here other than going to Dickinson Law School and coming back. And I've thoroughly enjoyed the campaigning process. It's been very rewarding, even to the point where if I would lose, which seems unlikely, but I might be able to mess this up. But even if I did, it's been a great experience, very affirming, very exciting. And the more I learn about it, just this morning I went to see the treatment court graduation ceremony, and it was truly inspirational to see that. And you can see the impact that these individual judges who add to their caseload and voluntarily take on these responsibilities, the fact that they can help transform an individual's life. This morning there was a mug shot followed by then a shot of the individual with their family after they had graduated from the program. So that's the kind of thing that took me from being, I'll say, reluctant and indifferent to just being absolutely inspired to have this opportunity.
We'll stay with you, Paul. In your view, what is the most urgent issue facing the York County court system today, and what steps could be taken to address it?
Yeah, I would say preliminarily, I'm not an excellent person to answer that question. The segment of the court system that I deal with is the civil litigation system in the Orphans Court Division. And my experience is those divisions are extraordinarily well run. If we go to court with an issue, whether it's an urgent issue or not, we get immediate court time, we get attention, we get prompt, thoughtful decisions. So in terms of urgent issues, I don't want to be presumptuous, but if I'm elected, I would dig into that and try to get a better understanding of that. I think on a macro level, just making sure that the court system adapts to the changes and challenges presented by the evolution of society. How do we deal with technology? How do we deal with different family structures? There seems to be a lot of issues with youth criminal offenders, breakdowns in families, and I think how can you maximize the efficacy of the court system and humanely, thoughtfully dealing with those issues?
Chris, same question?
So from my perspective, I believe one of the most pressing issues facing the York County courts and probably all courts throughout the nation is the erosion of civility. When I first started practicing law 25 years ago, and don't you hate when people sort of go back in time and everything was better 25 years ago? But I truly believe there was more camaraderie amongst the practitioners. I believe there were better relationships amongst maybe some members of the bench and the bar. And I think somewhere along the line over this 25 years of my career, we've lost some of that. And I don't have the magic bullet, and I'm certainly not proposing today that my election or Paul's election to the bench is going to change any of these issues. But I think we've had conversations along this whole process, and we've both discussed the challenges of what it is like to practice law. It's a very difficult profession. It's stressful. Clients are challenging. And so I think we're going to bring that mindset to the bench with an understanding that these are challenging times. We're dealing with challenging issues. We're dealing with challenging personalities. And what can we do to turn the temperature down a little bit? And what can we do to get back to meeting each other in the middle, understanding each other, our different plights and difficulties and challenges, and ultimately just treating ourselves, our people, more respectfully. And that includes lawyers, that includes participants. I'm just a very big believer that if someone is treated well, if someone is listened to, if someone is treated respectfully and with a level of compassion, they may win or they may lose, but it'd be difficult for them to walk out of a courtroom and say that it's unfair, they were cheated, this person's on the take, this person's this or that. And so, again, I think it's a challenge. It's societal, and I'd like to play some meaningful role in trying to figure out if there's a way to make it a little better.
Okay. Stay with Chris for a second. How would you enforce a law that you do not agree with on a personal, moral, or religious grounds?
So I really find this hypothetical fairly easy to answer, and that is it's not challenging at all. If I'm lucky enough to be successful and be elected judge and sworn in, the oath that I will take will be to the Constitution and to the rule of law. It won't be to my moral beliefs, it won't be to my personal beliefs, it won't be to my religious beliefs. It will be simply to the Constitution and the rule of law. And so I may not like a law, I may disagree with it, but our job is to call balls and strikes. Our job is to interpret the law that the legislator presents. And there's a very important reason why that is. And some people say, well, how can you not have morals? Well, that's not what we're saying. We all come to this job with our beliefs, with our morals. It's part of who we are. It's part of how you take in information. But as far as how it dictates whether or not a law is good or bad is just inappropriate in our system. And there's a simple reason. And we've had a really great lecture tonight by someone far smarter than me in political science. But there's a reason why these terms are 10 years and why in federal court they're lifetime. Is because if you essentially don't like a law, then you as the people should be able to vote to change that law. And so that's why our legislators stand for election every 2 years. They go out amongst the people, they say, this is what I believe in, these are the laws that I think are good, these are the laws that I think are bad, and we get to make that decision. And we can vote people out, we can change laws, but from a judicial standpoint, it's simple. The law is the law, and you interpret it, and you make a decision based upon what that law is.
Paul, same question?
This is one of those times where it's nice to be running with somebody who is younger, smarter, and more eloquent, and some say better looking than me. So I will simply incorporate by reference his answer, adding only that routinely as lawyers we're presented with a circumstance where we have to argue a position or argue for a client. And there are times where we undertake that. And this is why sometimes lawyers get a bad rap, but sometimes you are forced to assert positions that you yourself may struggle with or have ambivalence about, but you nevertheless do it. And I think Chris is right, absolute rigor with respect to fidelity in the application of legal principles in a fair way, regardless of any individual feeling, is absolutely critical to the system.
Great. Paul, what are your views on whether the court deals effectively with racial and gender bias?
I'll again preface this by saying, I'm probably not the best person to divine this issue. My practice experience has really been limited to civil division and orphans court. I can tell you that in 30 years of continuous practice of law in York County, I'm very happy to say that every time I left that courthouse, I didn't win every time, but every time I left that courthouse, my case, my client's cause had been adjudicated in a way that was fair. And that I left the courthouse feeling like even if I didn't prevail or my client didn't prevail, that we had a fair hearing. So I have not detected any types of biases in the court system, but I'm also thoughtful enough to say that doesn't mean they don't exist just because I, based on my particular circumstance and practice, have not directly encountered them. I think we have to constantly be vigilant about those issues because on a macro level, it is really prejudicial to the administration of justice if people exit a courthouse believing that some factor other than merit or fairness caused them to not prevail. On an individual level, it's tragic if somebody leaves a courthouse feeling like how they look, their ethnicity, their race, their religious views in any way impacted adversely the outcome of that proceeding. So I think, as a judge, I would try to be very vigilant of that, of all participants in the court system, and try to be very proactive in dealing with it, because I think it's critical that everybody, to the extent possible, perceives that they're being treated fairly.
Chris?
So I do think there are challenges within the system as it relates to racial and gender equality. Now, I am abundantly mindful that York County is about to elect two, no offense, Paul, but two old white men. And so again, maybe we are not the flag bearers for this particular issue. I believe that, number one, I think there should be diversity on our benches, and I think York County has some work to do. We've got a number of really talented female judges, trailblazers like Judge Cook, and just a fantastic bench of a number of female attorneys. We do not have any current members of the bench who are African American. We had Chuck Patterson, who was a true mentor of mine, who was on the bench for several years until he died, unfortunately, at a very young age. And I think we need to, as a society, as a community, look to see what we can do to always make sure that we promote some level of diversity, because different viewpoints are wonderful. And somehow this has become sort of a hot button and challenging issue in society, whereas if we sort of promote diversity, somehow we're pushing someone down. And I've just never believed that. I think the role that we're running for is to promote independence, promote equality. And I think if equality comes in different fashions and different flavors. And so again, I agree with Paul. I believe our York County court system functions at a high level. I believe there's no distinct or direct bias that affects the outcome of proceedings. But I also know that there are things and concepts such as implicit bias that plays a role that we just have to be mindful of when we're making these decisions affecting people's lives. And so, like everywhere in society, like every person, we're works in progress, and I think there's ways that we can always improve.
You touched on this next question a little bit in an earlier answer, so you could pass if you'd like to or address it, Chris. But how can judges support civility in the courtroom?
So again, I'll just very briefly, because I've already discussed it, but again, I think leading by example is the best way you can do it. And again, I've had the great pleasure of appearing before so many wonderful judges throughout my career, and the ones that have the most civility in the courtrooms are not the ones who mandated, or not the ones who dictated. It's the ones who sort of, again, lead by example, treat people fairly, treat people with respect and dignity. And I think if you do that, you set the tone for your courtroom, and that goes a long way in having more civility.
Okay. Paul?
Yeah, again, I think Chris put it very well. I think, leading by example is always the best way to do this. I have been in other jurisdictions where, ironically, you have a judge yelling at counsel to be civil, and I think it kind of undermines the principle that is being pursued. But I think, from the judge's end, I think running a thoughtful, dignified courtroom, I spent many years, to cite Judge Euler as an example, like it would never occur to me to misbehave in John Euler's courtroom. The sense of solemnity coupled with fear was such that, you want to behave.
Sorry, Judge.
But I think, there are even subtle things. I already envision if I was presented with a situation where, a young attorney was so enthusiastic that they were getting aggressive in a cross-examination, I would call up a sidebar. I wouldn't want to embarrass them in front of their client by upbraiding them. I would pull them to the front of the courtroom. Other opposing counsel would be there, so it's not ex parte, and convey to them the concern that the efficacy of their advocacy was being impaired by the degree to which they were being uncivil to a witness, and it may reflect negatively upon them, on their client, on their cause. So I think at every step of the way, trying to lead by example and trying to convey that you believe in these principles such that you maintain decorum. Judges face difficult situations. It can be frustrating, irritating, repetitive testimony at times. I think controlling oneself and, exhibiting good behavior, civil behavior, engenders it in everybody else who's in the courtroom.
For this next question, maybe we leave civility off the table just for the sake of the answers here. What qualities have you seen in a judge that you would like to emulate, and what qualities have you seen that you would not like to emulate? Other than civility, of course.
I think it's critical when we look at these things to have a high degree of legal scholarship. Thoughtful, well-reasoned decisions expressed well in ways that are understandable, and it makes it easier for a party who gets an unfavorable outcome to accept it if they have a well-thought-out, well-reasoned, well-written decision. So I think in terms of looking at those, emulating that objective of at all times being serious but being deeply thoughtful, and having the participants know, somebody's got to win, somebody's got to lose, but that the person who made that ultimate decision, and it can be an utterly crucial decision. I mean, the things faced in the Court of Common Pleas, termination of parental rights, outcome of a will contest proceeding, capital murder case. I mean, these things are so serious to the participants in the system, but always conveying a very thoughtful approach to it that everybody, whether you win or lose, can walk out of that courtroom and say, I believe in the system of justice, and what I just personally experienced enhances my view of it.
Chris?
Yeah, so I've certainly put some thought into this. As you sort of go through this journey, you begin to sort of Rolodex all of the judges you've appeared before over the course of your career. And what you can hopefully do is to begin to take bits and pieces of those judges and the things that made your experiences in their courtroom pleasurable. And then on the flip side, look at things that made experiences less than pleasurable. And I think to myself of certain judges I've been before, decisiveness is just such an amazing quality in a judge. And it probably, you assume to yourself, well, of course, they're judges. They decide. They've got to be decisive. And I will tell you that that is not universal. And there are some judges that struggle with making firm decisions after hearing people out. And there's a few in my mind that I think of that were just so fantastic with gripping the issue or grasping the issue immediately, understanding the parties, listening thoughtfully, and giving a decision that was generally right. And I just think that that's just such an amazing quality, and I know it's going to be a work in progress, but I know it's something that I want to do. And then kindness, empathy. I think these traits work well in life, and I think they work well in the courtroom. And so I believe that that's a very necessary component of a decent judge. And then if we're looking on the flip side, the things you want to avoid is arrogance, lack of humility, being mean-spirited. Again, I don't think we're dealing with rocket science. We don't like that in our own life. We don't like that in our living rooms. We don't like it in courtrooms. And so again, the goal is to try your best to sort of emulate the best qualities and sort of do what you can to repress the worst.
Thank you. While serving on the bench, do you believe you have a role in bringing important legal or judicial issues before the public or the legislature? Why or why not? And what should your role be in that?
So it's interesting to sort of give my opinion on that when I'm sitting in a room with probably 150 years of judicial experience if I look at all these judges out here. And so I don't know what I don't know at this point, and I'm humble enough to know that I'm interested in learning how expansive this job can be and what I can do as a judge outside of the courtroom to make my community better. I certainly think there's a role, and I look at my friend John Euler. Judge Euler took on an issue many years ago of truancy in schools. And, you think to yourself, so a kid misses school. Well, Judge Euler was on the front line of juvenile courts, and he saw what truancy from schools was doing to a generation of our kids who didn't have people getting them to school, making sure they were in school, making sure they attended on a daily basis. And so you could sit back a judge and say, well, that's a problem. But he commandeered community leaders. He did what he did to you, Scott, to get his courthouse built. He gets you in the room and convinces the people who have stakes in the outcome of these very important matters to get involved, to get engaged. And really, as a force of one, after he got a following, made a significant impact on that issue in York County. And there's probably a generation of kids who got to school more often, got a better education, and who are going to be better members of our community because of this judge. And so I love that, and I want to find ways that can be done, and I'm open to those opportunities for sure.
Paul?
I'll again incorporate by reference, but I agree with Chris. I think bringing issues that are significant to the judicial system to the fore is certainly an appropriate role for judges. There are ethical restrictions on the extent of advocacy on issues that aren't directly related to legal system improvements, but I do think it's incumbent upon judges to try to accomplish what is in the best interest of the public. And it's one of the nice things about campaigning. There is this political aspect to this, and Chris and I have developed great relationships with critical members of the state legislature and the county commissioners, and I think those types of relationships also facilitate one of the most critical things is making sure there's adequate funding for the court system, for treatment courts, for wellness courts, for supporting services. So I think the best type of judges care about justice on all fronts, not only in their courtroom but in the public arena.
All right, we're going to move on to some fun stuff, learn more about you as people. And I just realized that I completely forgot to have you do your elevator speeches. So did you get those? If you'd like to do those, you can do those now, and then we'll do the lightning round.
So the elevator speech, we were told we could only use 27 words. And if you have no idea how difficult it is for a lawyer to say something in 27 words, so I actually wrote it down so I'd stay over 23 points. I'm running for judge because I believe I possess the experience and temperament needed to fairly and honestly settle disputes, resolve questions of fact and law, and improve my community.
Just for the record, that was 29 words.
Lawyers.
I am running for judge of the Court of Common Pleas of York County. I hope to bring fairness, thoughtfulness, and strong legal scholarship to the position.
Okay. Just for the sake of simplicity, we'll just go Chris, Paul for the lightning round here. These are just simple, quick, one or two word answers. First job and or worst job, Chris?
First job, miniature golf course in Dover when I was 14. Greatest job too, probably. Worst job, working in my dad's bar. You'd smell like smoke for 2 weeks.
Paul?
Cashier Weiss Markets is first job, worst job, janitor at York Hospital.
What is something unexpected that most people do not know about you as a person?
Well, I don't know what time it is right now, but generally I'm in my pajamas and ready to go to bed right about now. So being out and about speaking here tonight is unusual for me.
People seem surprised I'm in a bowling league.
Favorite pro sport and team?
Football, Steelers.
Ooh.
Exactly. Football Ravens.
Go Birds, sorry. Guilty
Remember that
pleasure.
when you vote.
Guilty pleasures.
Maple donuts.
Yeah, generally carbohydrate consumption.
Cat or dog?
Dog.
Cat, too.
All right. Dream job?
The one I'm asking, the one I'm asking all of you to vote for me to get.
Okay.
And if we're going dream, linebacker for the Steelers.
There
But
you go.
genetics and reality make that not a possibility.
Hidden talent?
Hidden talent. I'm pretty good at golf.
Paul?
Most of my talents are very well hidden. You can just ask my wife. I would say table tennis or ping pong.
All right. All right. Spirit animal?
Yellow lab.
Jeez. I have to take this under advisement and issue a decision in 30 days. I guess a lion.
Okay. Superpower wish?
Superpower wish. Well, for reasons I won't go too deeply in, the ability to heal someone.
I like that. Paul?
I think I'll go with invisibility.
All right. Favorite movie?
Godfather, 1 or 2.
American Beauty.
Okay. I was just watching Family Guy before coming over here, and they were doing their version of it. It was pretty funny. Biggest fear?
Snakes.
Failure.
Pet peeve?
That's a tough one, because I've got probably a lot. Pet peeve. I'm gonna pass on that one. Sorry, Paul.
It's all right. People talking in a movie theater during the production.
I'll adopt that. That's good.
Okay, the agony's almost over. Favorite ice cream?
Fish food, Ben & Jerry's.
All right.
Mint chocolate chip.
Okay. And last song played?
Before coming in here,
Yep.
oh, geez, this is embarrassing because I know exactly what it is. It's, Let's Get It On by Marvin Gaye. And it was just Amazon music, you know, so it wasn't just random.
I don't know what he was expecting here tonight.
I think that's a great place to end it. Thank you so much.
Other one down.
All right, thank you all. I hope you have learned today from our candidates. Thank you, Chris and Paul, from our current judges and past Judge Euler and Judge Musty Cook, from our wonderful presentation from Professor Amspach, and Scott, thank you for moderating. Just one takeaway. You heard from the presentation, judicial independence is important, but it's also extremely weak. It needs you all to support it, to spread the word, to share what you learned today. So thank you for listening, and have a good evening. Get home safely.